Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed Scott Walterbach of Bessing Walterbach LLP based in Kansas City, Missouri. Scott has been practicing law in the tax sale industry since 2005 and specializing in his home state of Missouri since 2007. In this niche area, Scott shares his wealth of information concerning the myths around Missouri and how his great state operates. So sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Hi, everybody. Welcome to this episode of Tax Sale Insiders. I'm Brian Seidensticker, CEO of Tax Sale Resources. And with me today, I have Scott Walterbach. He's an attorney from the great state of Missouri. Hi, Scott. How's it going?
Wow. Good morning.
Welcome.
Good to be here. Thank you.
Thanks for hopping on and helping, I guess, unravel some of the mysteries around Missouri tax sales. I guess one of my favorite questions is how folks got in the industry, because it's not something you typically you grow up wishing you could do or become. And so, just out of curiosity, how did you land yourself in the tax industry?
Yeah, so I'm from Kansas City and grew up here, and then I went away to law school in Indianapolis and started working for a very small firm. They had 3 other attorneys and 2 staff people. Started working for them in 2005, probably, and they had a tax sale investor client, and so they had some ongoing quiet title litigation, some of them with some thorny issues. So I was helping them over the summer kind of do some research and figure that out. And then as I went back to school in Indianapolis, I kind of worked remotely. I do a lot of research and send them memos or parts of briefs to be filed with the court, things like that. So that sort of morphed into what it's become now. That firm, the partners were much older, and they retired and moved to, I think, Florida and that sort of thing. And so I left the firm, and I didn't necessarily take the client with me, and I kind of stopped doing tax sale work altogether for about, 4 to 6 months, I'd say. And then the client came back to me and said, "Hey, our cases aren't moving. We want to try going with you." And so that's what we did. And I've been kind of doing it ever since. You're right. Nobody really sets out to be a tax sale attorney, but I have also found it to be a really rewarding area. First of all, it's a niche area. There's not a ton of attorneys that do this, even in Missouri that has a lot of tax sales. I've come across maybe 3 or 4 other attorneys that know tax sales in Missouri the way I know tax sales in Missouri. Of course, any attorney could pick it up and learn it and write a brief or whatever, but they don't practice in it every day the way that I do. And so I found that to be interesting, that's sort of unique. And I feel like I'm sort of blazing a trail or figuring it out on my own, and at times even making case law. So, I've really enjoyed all that aspect. Plus it gets me into litigation. So it gets me into the courthouse, gets me into rules of evidence, rules of procedure, and all sorts of other areas of law that, I might not otherwise see or do. So I found it very rewarding and very interesting, and I've just always kept doing it. So I've been doing it since about, I've been doing it for probably 13, 14 years now, and hopefully I'll keep doing it.
Yeah, well, it is a very interesting industry, and it's something that from the outside looks very bland, but I tell you what, I learn more on a daily basis in this. You mentioned a niche, very, very niche industry than I ever did. And I used to work for an aerospace rocket launch company, which sounds amazingly interesting, but on a day-to-day basis, this by far exceeds my previous life, as I call it. You bring up a very good point about not very many attorneys are familiar with. You mentioned tax sales in Missouri, but I think that's actually standard across the board nationwide, where we recommend and folks recommend talk to an attorney. Well, it definitely behooves people to find the right attorney. Otherwise, they're paying for folks to learn it. Any attorney can learn it, right? But then you're paying the time it takes and that it took you to get that experience. And so finding an attorney that knows what they're doing already and is active on a daily basis within this industry is paramount.
I talk to people pretty regularly that are some are in need of some are under a time crunch or under stress, and they need to find an attorney. And I tell them, slow down. Finding the right attorney is sometimes half or 75% of the battle. Mm-hmm. That's the key. You got to find somebody to do it. Yeah, an attorney could pick this up and they can read a statute and they can try to defend a case, but they don't really know it the way that I've come to know it over 13, 14 years. So finding the right attorney is key.
Yes, absolutely. I agree with that 100%. Well, I guess I did do my homework, believe it or not. I did. You wrote an excellent, let's see if I can put it up there so people can, Scott wrote an excellent white paper. It is a bit of a beast. It's about almost 100 pages, but it's got great detail and explains the statutes in English as opposed to legalese, as I call it, and really bust some of the myths regarding tax sales in Missouri. And so if you choose or you prefer to read rather than watch this, I would definitely recommend reading his white paper. But that aside, I guess let's dive right into it, Scott. I guess let's go through the basics. I guess, do you consider Missouri a tax lien state or a tax deed state, or like a combination of it?
Yeah. So generally speaking, Missouri is a tax lien state. So you're buying a tax sale certificate of purchase at a tax sale, and then the state sort of delegates their obligation under the statute and under notions of constitutional due process. They delegate that to the tax sale purchaser. So you take on that obligation. If you do everything the way they think it should be done, then you can get your deed. So it'll ripen into a deed. But there's plenty of case law out there that says in Missouri, you did not buy the property. You bought an inchoate or imperfected interest in the property, that if you meet all the requirements of the statute, that it can ripen into a deed. There are a couple of other sections of the statute that govern tax sales in Missouri. So one of them is Chapter 92. And I have very little familiarity with it because, as far as I know, it's only used in one county, which is St. Louis City. And yes, I said that correctly. St. Louis City is its own county in Missouri. And so there's a lot of, outside of just this area of law, there's a lot of different laws written specifically for St. Louis City, just because of the unique nature of the city as a county and the population density and all that sort of thing. They have specific needs that are different than a lot of the rest of the state. So they operate, as far as I know, under Chapter 92. Mm-hmm. And it's, I don't know a ton about it, but I know that it's basically a judicial foreclosure process where the collector is filing a suit. At least that's what it appears to me to be on a quick read. The other one is Chapter 141. And that's used, as far as I know, exclusively by Jackson County, Missouri. And that's basically downtown Kansas City and some of the first-ring suburbs around there. So Chapter 141 also is a judicial foreclosure process. I don't really get involved in that because there's not a specific role that an attorney really needs to play in that. The extent of my experience there is that I represent a judgment creditor recently. I represented one that had an outstanding balance, and the judgment debtor was the former owner of the property. There was a surplus from the sale of the property, and I applied for it, and we recovered it and paid off our judgment balance in full. So I've been involved in it a little bit, but I'm not regularly involved in it. I'm not representing tax sale purchasers like I do in Chapter 140. There's 114 counties in Missouri. All of them, except for those two that I just mentioned, Jackson County and St. Louis City, use Chapter 140. So what I know about Missouri statutes is basically what the entire state is using, save for a couple of unique, densely populated urban counties.
Got it. Okay. So it's we'll call it Missouri because over 99% of it, or 98% of it is a lien state, and then there's a couple counties that have the option and do utilize the other statutes, which really govern more of a tax deed auction or style of foreclosure. Excellent. Okay. Well, tell us a little bit of history of tax sales in Missouri in general. I know in your paper you go into the Jones-Munger Act, I think in 1933. How far back did tax sales go? Was there a lot of change to get to where it's at today?
There's not a lot out there on Missouri tax sales pre-1933. Most of the research that I've done is in, appellate court opinions and things like that. And they basically talk about what has happened since 1933, which is basically when Missouri implemented a non-judicial foreclosure process for real property taxes in Missouri. And so my understanding is that before 1933 was some sort of judicial foreclosure process, perhaps looked a lot like Chapter 141, but that was the Great Depression, and maybe that's what led to the change. I wasn't around back then, obviously, so and there's just not a lot out there on it. But Jones-Munger in 1933 was really like, the court opinions that I've read refer to it as like a groundbreaking piece of legislation that it really changed everything about how Missouri tax sales work. And so now we've been dealing with non-judicial foreclosures for about 100 years. And my impression is that there was some case law early on in the 30s and 40s and 50s, but I'm not aware of a ton of actual legislative amendments to the statutes. There probably were some, and if I dug a little bit deeper, I'm sure I could find some. I'm looking at one of the sections right now, several of them that looks like they were amended in 1939. So things like that. So they've been tweaking it, but there have been a lot of changes in the last 30 years. Okay. I've really dug into some of the amendments in 96, 98, 2000, 2003, 2004, 2005, 2010, and then 2011, 2013, and then even in 2015. And then we did some more in 2018. So there's been a lot of movement on this lately. I have some suppositions about why that's the case. Just because of the nature of financial literacy in our country, I think is on the rise. People's interest in their credit report and people's interest in how these things are collected and how it works and all that, I think has just been on the rise lately. And so, and the other reason I think that there's been a lot, relatively speaking to other statutes in Missouri, there's been a lot of amendments, is because most of the amendments that people want are for the sake of clarity as opposed to changing fundamentally what the law is all about. Mm-hmm. So just like we've been almost like adding more clarity to it, and the Collectors Association has always been in favor of more clarity and less sort of, well, it's a gray area, I'll just do what I want. It seems to me like their primary interest is in gaining more clarity so that it's an even playing field, and that the playing field is both balanced and understood by all parties involved, including not just the collectors themselves, but the tax sale purchaser and homeowners and lien holders that all have an interest in how this process works. Because I've heard collectors talk about how they view their role in the whole tax sale process is to make sure that the parties understand kind of the rules of the game and that it's administered fairly, so that you get to a foreclosure that appropriately balances the interest between, homeowners and lien holders versus tax sale purchasers.
Got it. Okay. So a boatload of changes recently, but more geared toward clarifying the existing statutes, not only, like you said, not changing the basis of the statutes or how sales are conducted. Are there any known changes coming down the pipeline that you're aware of that would further clarify any of that or change anything right now?
There are not that I know of. One of the other reasons for some of the recent changes is that the Missouri State Tax Sale Commission, there was sort of this quasi-governmental body that would they put out they published a manual, probably not every year, but they published a manual about how they kind of believed these things should work. And so I think collectors generally just followed that. Well, that they got rid of that. That was in 2011. And so that's another reason for some of the recent changes. I'm not aware currently of future changes coming down the pipe. There are probably ideas out there, but I kind of think we've gotten to a point where most people understand some of the law and that it's generally working right now. But I also, just because of COVID and everything else that's going on in my practice and being busy, I haven't as much, had my finger on the pulse of it as I did maybe, 2, 3, 4, 5 years ago as well. So that's probably something I can dive into more, but usually I'll come into some knowledge of this based on just collectors I know or lobbyists for other trade groups that we use will let me know if there's something related to tax sales. And as far as I know, in the past, so Missouri's legislative session is from January to May of every year. And so generally I'm kind of reviewing bills in November and December when they're pre-filed. And I haven't seen really much of anything related to tax sales. I also haven't really seen a lot of heavy hitting Missouri Supreme Court decisions on tax sales, because I know one of my cases that was in the Missouri Supreme Court, that became the impetus for more clarity in the statute for them to make a change. So it was sort of like we called it a legislative abrogation of that case. So sometimes when there's a lot of activity on the judicial side, then you get some responsive activity on the legislative side. And it seems like some of that's been quiet here in the last few years.
Got it. So Missouri as a whole is pretty stable as far as compared to some states right now. I know Alabama just had a pretty massive Supreme Court case that came out that changed how sales can or will occur in Alabama going forward. And I know there's many changes in several other states related to really impacts from COVID of now allowing them to go to online sales, et cetera. But Missouri as a whole is fairly stable, it sounds like.
There's nothing in Missouri law that prevents an online sale, and so a lot of collectors have gone to that recently. There was a couple that were, I think at least one that I know of that was doing that prior to COVID, and I think there's probably several more I know there's several more that did it in response to COVID. So that may bring up some legislative changes, but I think for the most part right now, it's sort of been it's sort of working for now, and we'll just kind of see how it goes. It's also kind of like the weather in Missouri. We say if you don't like the weather in Kansas City, wait 10 minutes.
Yeah, It's I heard that growing up in Montana as well. It's weathermen have a pretty easy job, just always be wrong, right? I'm gonna go back to the basics a little bit. We mentioned online sales. So how are auctions conducted? Are they on the same day? Are they spread out through a few months? Are they online? Are they live? Explain a little bit of that to me.
So you'll probably hear this a lot from me, but it varies much from county to county, except for when they're held. By statute, they have to be held on the fourth Monday of every August. So
Okay.
taxes become delinquent on December 31st. There's basically a, if you're talking about the fourth Monday in August, you're talking about almost a 9-month period of delinquency where nothing really happens. I'm sure there's some collectors that send out notices and things like that, but in an attempt to collect what's delinquent. But so you have a 9-month period there, and then they go to they generally go to auction the fourth Monday in August at 10 a.m. And then they can, by statute, that's in the statute, and they are supposed to continue from day to day until the sale is done. Now, there's a choice that the collectors have about how delinquent properties taxes have to be before they go on the sale. You can put it on the sale after that first 9 months of delinquency. You could also wait, and many counties do this, especially the more populated ones, it seems to me. They wait till it's a year and 9 months delinquent before they'll put it on the tax sale. And then there's a cap of 3 years. So basically every county would be putting them on at 2 years and 9 months of delinquency. And then there's some in response to COVID that used to do it after a year or after 9 months or after a year and 9 months that have switched to doing it at 2 years and 9 months. I have my own feelings about the futility of that, but that's what some have done. Most collectors are elected offices or at least appointed. And so they have some of that. There's a political backdrop to a lot of how that works. So yeah, it's mostly on the same day. Now, as far as how the auction is conducted, I've recently dug into this because I was trying to figure out what, if any, parameters there were for how the auction is conducted. And there's really not a lot. It basically just talks about an auction and a sale of tax sale certificates. For example, Missouri doesn't even specifically say, although I think it's implied in several areas of the statute, it doesn't even necessarily say that the high bidder wins the auction. I mean, I think it's implied, and I'm pretty sure that's how everybody does it. But there have been some issues come up because of COVID about how the online sales work. And there are some counties that have gone to more of like a silent auction type of bid or a prepaid auction type of thing. And I think collectors probably have the discretion, probably have pretty wide discretion on how to do that based on the needs of their county. And a lot of it depends on the value of the property at stake, but also the volume of properties in the sale. So there's not a lot on the actual structure of the sale. I think most of them, certainly prior to COVID, were generally done in a room with all the bidders that had cards, just like you would typically think of an auction. Mm-hmm. And there would be numbers or numbers called out and that sort of thing. But there's probably others that did it somewhat differently, either by silent auction or prepaid or caps or reserve. I don't know. There's probably lots of different ways that they did it. I'm familiar with some of and I've been to several tax sales like around the Kansas City area, but I'm sure there's a lot of variation just among all the different counties.
So in general,
go to more than one because they're all on the same day. So usually I go to the one. It's not like I can go to one this week and go to check out a smaller county next week.
So if you're gonna go to multiple auctions, you definitely need to have a well-educated team to do that on your behalf.
That's right.
Now, is it there's lots of different styles of auctions, meaning some states like Florida bid down the actual percentage that you earn. Other states, oddly enough, do an ownership bidding route. Is Missouri more? The standard route is I call premium bid, right? You sit there and you say, I will bid X dollars above the opening bid amount in order to buy that lien. Is that how most of Missouri works, at least?
Yes. So Missouri only pays interest on the amount of taxes due. you can bid higher than that, but you don't make any interest on that. And so you would need to factor in that dynamic into your bidding. So, and then so I think it's 10% generally, although Missouri says it's not to exceed 10%. So maybe there's counties that do it lower than that. The ones that I'm familiar with all do 10%, and then it's 8% on any subsequently due taxes that you pay. But yeah, so you would want to factor that into what you're going to make on your money if it redeems after, a year. Let's say you're parking that money, but if you park too much of it, then you really haven't made much of any interest if you've bid a big surplus. And this comes into play a lot of times when you have an auction where, say a novice bidder has a particular interest in a single property and they're willing to pay whatever for it, maybe because it belongs to a family member or it's adjoining their current property, and so they want it for that reason. So they'll bid whatever because they don't care about making any money on it. They're not a sophisticated investor, and so then it becomes more of an auction strategy of, are you going to try to bid them up and drop it on them or that kind of thing.
Got it. So there are a few that more look at it as, I have the potential of owning this as real estate. They're not looking at it as an interest earning situation. Yeah. And they're bidding at it as if they're going to own the property, which is still a very rare occurrence. Most stuff redeems.
Yeah, I've never run the numbers in any county, but just anecdotally, my impression is that maybe 70 to 80% of stuff redeems.
Okay.
Maybe it's 60, maybe, I don't know, but it's probably somewhere in there.
Okay. But a vast majority redeems ever before it becomes.
It's definitely a majority. Yeah.
Okay. Now, let's talk a little bit about that redemption period. So you go to the auction, you bid, you're bidding a premium. You don't get interest on that premium, so you got to take that into account, whatever your strategy is. You win that lien at the auction. How long is the redemption period? Is there anything you have to do during that redemption period? And then you mentioned, subs are at 8% automatically. How does that whole process work for redemption?
Well, this is where the rubber really meets the road, so to speak. So if you're the winning bidder, you got to pay it right then and there. And different counties do it different ways. Some of them want certified checks and they'll give you time to go get it. Some you can wire money in, some you can prepay a certain amount and then kind of settle up the difference if you're going to be bidding. So those are details to be worked out with the collector. Generally, from that fourth Monday in August until March 1st, you do nothing except for pay those subsequently due taxes as they come due in December. So you'll do that, and you really don't want to let those become delinquent because there's a possibility that you could lose your interest in the property if that happens. So the statutes then provide that what's happening here is the statutes are structured in such a way as to acknowledge the fact that this is state action and a taking of private property, which implicates both the Missouri Constitution as well as the United States Constitution. And so what the state functionally has done with the non-judicial foreclosure process is say, okay, the collector is going to be in charge of conducting this sale, but they basically whole cloth got out of the business of sending all these notices. Now they still have to send certain notices and publish certain notices before the sale. So they haven't totally gotten out of it. But after the sale has occurred and before that certificate ripens into a deed, there's a bunch more diligence that needs to be done. And the statute says that really you could do this diligence anytime, but none of the costs associated with it are reimbursable with the redemption unless it's done after March 1st. And that's relatively new in the last few years. So March 1, basically, you order the title work from a title company or an attorney, but I don't know any attorneys that would even dabble in this kind of thing anymore. It's all done by title companies. So you get your title report and then you pay for that. And if you've got it really down to a science, you'd be reporting all these costs to the collector. Sometimes it's just as simple as like an email or a copy of the invoice or whatever, reporting these costs as you go. So that way, if somebody comes in to redeem, those costs are part of that redemption amount. You review the title report and see who owns the property or who has lien in it. And then it becomes your responsibility under Chapter 140, Section 405, to give them a particularized notice. And you want to use some of the language within 140, 405 as to what the notice must say. But separate from that, going down a parallel track, there's also a whole bunch of case law about what the Constitution requires that notice say. And so you're trying to thread the needle here by giving all the information you're required to give in the statute, and then perhaps some additional information that the Constitution, the courts have said the Constitution requires, but then not going so far as to be considered legal advice to an adversary. And so the exact language of those notices really matters if you're going to ultimately prevail on a challenge to one. And so I have my forms that I've developed over the years that I promulgate that people use. Do I guarantee that they will withstand a challenge? No, but it'll be a dogfight if they do, because it's as good as I know how to make it. I've seen people do really basic notices. I've seen people do like handwritten notices that just kind of quote the statute. And to me, a lot of those things aren't really good enough. And so an attorney that's experienced in this, that understands both what the statutes say now, because anybody can look up the statutes, but also that has done the research on what the case law says, what judges say that the Constitution requires. You need to get that in there too. So once you send out all your notices, then there becomes an obligation not just to dispatch them in the first place, but then to follow up on them as well. So it used to just be that the courts would evaluate your knowledge ex ante, which means at the time you were sending them. And as long as you did what a reasonable person would do to give actual notice, consistent with a real desire to give people actual notice, then you were good. Well, some of the Supreme Court case law cases that you're probably familiar with, Board of Mennonite and some of the cases out of Indiana and that along those lines, some of the other names escape me. In Missouri, it's Schlereth v. Hardy, and those there's plenty of them that I referenced in the white paper. They basically said, yeah, you can't just ignore it if it comes back now. Now we're going to look at the totality of what you're doing, not just when you dispatch the notices. So you have a continuing obligation, both under the statute and constitutional due process, to follow up on those notices and to do more, to do something more. And the statute's not real specific about that. And frankly, neither is constitutional due process, as you might imagine. It's kind of a reasonableness standard. But basically, you want to try to do everything within your power, within reason, as far as expense goes and time goes, that would be consistent with your desire to give people actual notice. So if you know they didn't, you might do a skip trace and see if you can find other addresses for them. Search through some public records, try to serve them personally if you know that they're elsewhere. Don't ignore known addresses or even known bad addresses. I mean, it's okay to send a notice to a bad address because maybe it is good again, who knows. But there have been cases where people have sent one to a known bad address and ignored what they thought could be a good address, and that doesn't fly. Mm-hmm. And then failing all else, publishing in a newspaper, posting a notice on the property, you can do things like that too. When you're done with all that, and after the 1-year redemption period, so remember how I said that parcels could be offered after a year, or after a year and 9 months, or that sort of thing. When they offer it the first time, if nobody bids, it just gets put back on the rolls for a second sale.
Okay.
Okay. So whenever they choose to offer it, maybe somebody bids the minimum amount, maybe they don't. If they don't, it goes back onto the second sale. Second sales and first sales are governed by the same rules. There's a 1-year period of redemption. And once you've let that 1 year lapse. You've done all your notices. Then you do an affidavit to the purchaser. I believe that that's outlined in 405 also. So you do all your affidavit in accordance with that. You need to kind of get in touch with the collector, because each collector does things a little bit differently as to how they want costs reported and how they want the affidavit. Some it's okay to email, some they want the original, that kind of thing, those administrative things. So you got to figure all that out. And then once you've turned that in with all your notices, they review it, and at their discretion, they can require you to do something more as far as notice goes, or they can approve it and issue the deed. You then also have to pay any subsequently due taxes, and then costs of recording, and there might be other, nominal costs involved that you have to pay. Then they go record the deed and give you a recorded copy, and you're good to go.
That's after the first and second?
Yes.
Right.
Now, if it goes back on the tax rolls, on the tax sale, it'll be on the tax rolls the whole time. But if it goes on the tax sale for a third time, then you're required to give them notice, just like you would in a first or second sale. But basically, you do it right away, and there's a 90-day period of redemption. Okay. Frankly, there's usually not much on third sales. It's usually pretty picked over after first and second sales. A lot of times you'll find strips of property, but you might want that especially if it's adjoining, or it might have value if it adjoins something else. So I do see some improved lots, with houses on them on the third sale. They tend to be fairly undesirable or in kind of rough shape.
Yeah. And
then for fourth and subsequent sales, there is no period of redemption. You just get your deed and you're gone. However, I still think in fourth and subsequent sales, you probably still have an obligation. It's still a taking by state action of a private property interest. I think you still should probably go through that 90-day notice period like it's recommended for third sales. But again, I don't come across a lot of this in my practice. Usually if it's not gone through, if it has gone through a first, second, third sale, there's some reason why people don't want it. And so sometimes it would either fall off the sale but you could go get a deed, and in theory, it's just yours. If it were me and I were doing it, I would still send a 90-day note. I would still go get a title report, send a 90-day notice, and then get my deed after that period of time. Just not because I need to for statutory compliance, but if I really want the property and I want good, clean title, then I need to do it for constitutional due process reasons.
Got it. Okay, so if it makes it to the third or subsequent, I guess probably better way to ask it is, the only way to buy the liens is at the auction on the fourth Monday every August. So if it doesn't sell this year, it'll be in that sale the following year and really forever. And it sounds like there may be a very small subset of very undesirable parcels that nobody ever wants, and they just continue on that path forever. Or does the county do anything different at some point?
Oh, I think after a while they can kind of stop pursuing it, but I've never really come across it much. That's more of a collector's probably come across that issue where they say, hey, we've got this separately assessed parcel. I don't know. Maybe they would go over to the assessor and say, hey, can we, who owns this, and could we combine it with, if it's owned by the same an adjoining landowner, could we maybe just assess it all together and reassess it? I don't know what they would do with it at that point. It's just never really come up. I have had clients buy third sale properties, and I've quite a title on third sale properties. But frankly, I've never had one on a fourth sale. I think it's just fairly uncommon. Now, again, I'm practicing there's 114 counties in Missouri. I probably practice in maybe half dozen or a dozen of them, somewhere in there. So that's not to say it can't happen, and maybe it does happen in rural counties and things like that. I just wouldn't have a lot of exposure to it.
Got it. Okay. And it's generally a 1 year total redemption period, but do that March notification time frame, you have to do that. That's the first time you can do it. But can you do it later? Is there a expiration to the lien, or does the
18
lien?
months.
Okay.
It's 18 months. So basically you have to wait that year. And it used to be 2 years. One of those recent amendments was they shortened that period. So now it's that your tax sale certificate, you have to basically do everything you're supposed to do if you want a deed and get it all done within 18 months.
Okay.
And so sometimes it gets a little bit, the window gets a little bit tight, because if you get your, let's say you get your, this is maybe typically how it would work. You bid on your tax deed in March. You get your, or I'm sorry, let me take a step back. You're going to bid on the tax sale certificate in August. You're really probably not going to do much of anything until March 1st. Not because you can't necessarily, but because if you do, then your costs are not reimbursable. And you want your costs to be reimbursable. You're going to have a couple $100s in costs probably. And sometimes more. If there's a lot of lien holders, sometimes that postage can really run up. So
real quick on that though, those costs, obviously you've got the title search costs, you've got the notification costs. Are the attorney fees, if they're involved at that point, are those reimbursable as well?
I think they should be, but most collectors take the position that they're not. And I think part of the reason is because the statute doesn't specifically say attorney's fees. And also, I'm aware of several situations where that has been abused pretty badly. And so what the collectors don't want to do is heap a whole bunch of costs into the minimum redemption amount, because a court could see that as an artificial barrier to redemption. And so it almost works like a, even though it may not technically be a violation of the statute, since the collector has discretion, it could be viewed as unconstitutional because the person didn't have a say in the amount of costs that came due. And so they don't want to be in the position of creating artificial barriers to redemption. And frankly, as a purchaser, you don't want to be in that boat either. Now, do I still recommend and advise to my clients that they report the amount of attorney's fees? Yeah, I do, because there's a link in that chain that's missing otherwise. You go get your title report and say it'll cost you, $150 or $200 or whatever it is. Well, I think it takes somebody with some training and some understanding of what that title report means to look at it and to determine who gets notice, and to do some diligence as to not only who gets the notice, but where they should get a notice. And those things aren't always clear. And so, there are certain clients that I do the diligence for, and I can tell you it's difficult and it takes a lot of time, and you're never going to make it bulletproof. There's no perfect way to do it unless you send notices unless there's very few notice recipients and they all sign for it on a green card, and then you got it. But in reality, that's not what happens. I mean, they come back for all sorts of reasons. And during COVID, all the green cards would come back with the delivering postal employees chicken scratch saying COVID-19. So we don't really know who got it. We assume that somebody got it because they filled out the return receipt, but so that's going to be an interesting issue also. I think I veered off the topic from your question. Remind me what it was.
This is great though, because you mentioned it's not just understanding the title search and knowing who to send, what and where. That what is complicated too, because like you said, that notice has to have very, very specific information.
Yes, and then also you gotta have somebody that's going to evaluate those things as they come back. Also, if they come back refused, or if they come back undeliverable, unable to forward, all those things, or they come back with a forwarding address. You got to have somebody that's looking at those things that can then send a follow-up notice. And it tends to help for that person that's evaluating those things as they come in to have been the same person or persons that originally dispatched it, because they know the history of it and what's been done so far. And if they're anything like us, they're tracking it on a relatively complicated spreadsheet to figure out, okay, what's been done so far? How did it come back? Now, what else do we need to do? So back to my original, I remember where I was. I was on the timeline. So you're going to order that title report at the very beginning of March. It's going to take them a little while to get it to you, especially if you have them in any kind of volume. You're going to try to get your notices. You're going to try to review all those in April and try to get your notices out on the street by beginning middle of May. And that's because then you're 90 days away from the 1-year anniversary of the sale date. And if you can line it all up perfectly, you can make that redemption period 1 year. Mm-hmm. If it takes you longer than that, so be it. It takes you longer than that, but the window for redemption continues to be open until you go get that deed. So it's not like at 1 year, they're out of luck. If you haven't got that deed recorded, it's whenever the deed gets recorded that the window of their right to redeem completely forecloses. Okay. So you try to line that up so that you can get your 90-day notices out. And I'm sorry, I probably skipped over that. One of the things that those first and second sale notices have to say in them is that they have a minimum of 1 year to redeem the taxes, and they also have 90 days to redeem whichever is longer. So if some of those notices come back, let's say you send them out in mid-May, you get it back at the end of May. Now you need to, and let's say it comes back with a forwarding address on there. Okay, now you need to send another notice, and you're at the end of May. Let's say it goes out at the beginning of June to that next address. Well, that's a 90-day letter. So now you're at July, August, you're at the beginning of September. Okay. And so that can go on for a while. Now, eventually all your mailed notices get done, and you may get to the point where you need to post the property or something like that. And that can be done. But what you don't want to do is run this to the point where you're still sending out notices in September or October, because then your 90 days is running into November, December, January, and you only got till February to get that deed recorded. So the window can close quickly on you if you're not careful.
Yeah, I think you answered that. My next question already is that 18-month expiration, is that you have to have everything done by the 18 months, or you have to at least started those notifications by that 18 months?
Deed has to be recorded by then. So you better have everything done, by then and well in advance of then, because you could probably make an argument that once you've done everything and submitted the affidavit to the collector, they could probably record it a few days after that deadline. But I don't want to be in that position. I want to get it to them a week or two ahead of time, because they have their own things that they're doing. They're not going to drop everything and jump on your application for a collector's deed. You need to get it to them in the normal course. For this year's sale, for example, we've applied for just about everything at the end of August, like I think it was the 26th this year. So we got most everything in. There was some subsequent noticing that we had to do, and so we have some others slated for application in mid-October. Mm-hmm. I really don't want to be taking it out to November and December if I can at all avoid it, because I think it's getting too close. And you're getting to the point where an investment can ripen into a deed, in which case that can transform the nature of the investment and probably make it more lucrative. And so, just as a service to the client, as part of like their business, going concern, you want to try to get to them. You want to try to put their investment in the most advantageous position, which is to get a deed as soon as you possibly can. Got it.
Okay. I want to touch on, I think there's been 3 scenarios, and there's probably more, but 3 that I've recognized here of issues. One is if you don't post those subs, I think you mentioned a potential of losing your interest in that property. The second one is if you don't do those notices right, or you don't do it at all, what happens? And then 3, and maybe this is separate answers for each one, but third one is, okay, you don't get everything done by that 18 months. What happens to your certificate in those scenarios?
So what would happen is that your certificate is a publicly recorded interest in the property. I mean, they do record those, but the statute says that it ceases to become a lien on the property if you don't get it done within 18 months. So good for you. You just lost your money if you don't get it done within the 18 months. Now, as far as notice goes, if you don't do what you're supposed to do as far as statutory compliance with the notices that you do, then it's likely nowadays that under the new statute, this was another change a couple years ago, where the collectors have the discretion to review that and not issue a deed. And so if you didn't, let's say you sent out 5 notices to 5 different people. Let's say there's a husband and wife owner, and then there's a couple lien holders, let's say a mortgagee and like maybe an IRS lien or something like that. So you send out your notices, but 4 out of the 5 of them come back as undeliverable and you don't do anything else. And you go to the collector and say, here's what I did. They're going to come back and say, yeah, well, that's not really good enough. We think you had a statutory obligation to do something more. What else did you do? And if you come back and say, well, nothing, they're going to say, well, that's probably not good enough. So it's either going to expire. They got their money, so they don't care.
Yeah.
So they're either going to say, here are the things that you need to do, or they'll just say, I don't know what you need to do, but you need to do something more than this. I found that most collectors, I think, have an interest in maintaining a good relationship with purchasers, and so they'll work with you. And if you have a good faith explanation of why you did what you did and why you didn't do anything more, or why that's all there is to do, I think they would be receptive to that conversation. I can't say you would ultimately persuade them one way or the other, but I think they would at least be open to having that conversation. That's been my experience. So I think there was a third one that you said. One was if you didn't get it done in the 18 months. One was if you didn't do the notices. What was the third one?
If you don't post the subs.
If you don't post subs. Again, they will probably just refuse your application and not give you your deed until those subsequently due taxes are paid. Because that's part of the statutory requirement. That's just something you have to do, as well as paying for the fee to record the collector's deed. It's, I don't know, $27 or something. You have to pay that too. And if you don't, then they're not going to do it. So typically that application to the collector would include an affidavit per the statute, as well as all the other things attached to that affidavit, which are required by the statute, such as copies of the notices that were sent, copies of the envelopes before or just immediately prior to mailing, copies of any envelopes or return receipts as they came back to you, and then any other diligence that you did during that process. But then it would also typically be accompanied by a check for whatever amount is due for subsequently due taxes and recording fees and all that. And then you would kind of give all that to the collector and let them process it.
Got it. So it's one of those, as the subs go, you might as well post them as soon as you can and earn some interest. You don't have to if you don't want to, but you're going to have to pay them at some point in order to get your deed down the road. Yeah,
there's some troubling language in the statute that says if you allow it to go delinquent, you lose an interest in the property. And so I tell all my clients,
post them
by December 31st, pay it, because you just don't even want to run into that possibility. Because what happens is that you think kind of abstractly that nobody really cares about this piece of property. You've sent out, all these notices and all these things. Well, once we get to quiet title litigation, then some of these people come out of the woodwork and they'll get an attorney, and man, they will nickel and dime this thing to death. And they will point to any little thing that you did, whether it's relevant in the analysis of what title passed by that collector's deed, whether it's relevant to that or not, doesn't matter. They will just throw handfuls of spaghetti at the wall until hopefully something sticks. Whether that's to gain leverage in a settlement with them, they want to stay in the property, or they want to give it to their whatever it is. So the best approach is, especially statutory requirements, to follow them very strictly, because I'm sure you and your investors in other states see this. There is a propensity for courts or collectors or whoever else to put everybody back to status quo and give the investor their money back plus some interest and say everybody's fine here. So strict compliance is always what I say. As it comes to subsequently due taxes, I would not let them go delinquent, because I think you may run into a problem there with some of that statutory language.
Got it. Okay. And then back to if you don't do your notices right or not on time, and you go to apply for your collector's deed, the collector's likely going to say, no, not good enough, go try again. And I guess, do you get as many chances as you need for the tax collector to finally give you the thumbs up, as long as it's within an 18-month period?
Yep.
Okay.
Yeah, exactly.
Okay.
So some of them are helpful. Some of them will kind of narrow it down and say, hey, the notice to this specific person came back. I want to know something about what else you did, or if you didn't do anything, why. And some of them will just say, no, your application is rejected. And you kind of have to try to figure it out. But like I said, I think most of them want to work with you because collectors, like I said, they view their obligation as having an even playing field and maintaining that balance between investors and homeowners. Yes, they want to protect homeowners from unscrupulous investors, but they also want to take care of their investors because those are the people that actually come in and pay the taxes. And most tax sale purchasers, in my opinion, they're diligent. They're they want to come into ownership of properties that are vacant and abandoned and that people don't care about anymore. They're not necessarily keen on kicking poor people out of their houses,
Right. They're looking at it as an investment opportunity, not an opportunity to go take property from somebody through this process.
Yeah, that's not the primary goal. Although that is an ancillary thing that happens from time to time, just based on the unique circumstances of each case that can happen. But that's not. I wouldn't say it's common at all.
Right. So you said the collector's deed. So you apply for this collector's deed. Is it a fairly fast process for them to give you an answer? Is it they're at the courthouse? Is it a couple month process? What's that?
It depends on the county. And it's funny that you say that. And I kind of laugh because I started thinking through each county that I'm kind of familiar with, and I'm just thinking like, oh, I know we're going to get the ones from this county probably in the next week or two, and then this county I think we're probably going to get in the middle of next month, and then this county it's probably going to be Christmas. So it depends, but generally it should in theory be a 2 to 4 to 6 to 8 week process. Really, it depends on how many you have and how many they had on the sale and everything like that. I can also tell you that if you apply for the deed right at the 1 year redemption period, remember the collector is holding that next year's sale at that time too. And they're more focused on getting this year's sale done and done properly. And then usually a week or two after that sale, like usually, the beginning of September, that's when they'll actually start processing those applications for deed.
Okay.
One unanswered question under Missouri law is if somebody comes in and tries to redeem after you've done all of your diligence and made your application, and the application is sufficient for the collector. I don't think we really know the answer to that. I've taken the position, and I have had a collector adopt this position, that once the 1 year has passed and I've submitted my application, as long as that application is retroactively reviewed to be sufficient, that the right to redeem is gone.
Okay. How about on the issuance of that collector's deed, right? It takes some time to get that. Yeah. You got to record it, I think is what you mentioned. So do you have to take that delay into account, in that 18-month expiration? You can't just walk in at 17 months and 29 days and say, I've done everything, give me my deed by tomorrow, right?
I mean, I would do that as opposed to waiting to 18 months in 1 day. I would get it on 17 months and 29 days for sure. But I'd be communicating with the collector and saying, hey, this is coming. I want to make sure. Yeah, that sort of thing. But like I said, generally we're applying for those deeds in either late August, September, even October if we had to do follow-up diligence, but we're not applying, in the middle of February or end of February when that deadline's approaching. So yeah, you would definitely want to take that into account and try to get it all done. I tend to think most investors are motivated to get a deed sooner rather than later, So a lot of them aren't just kind of sitting around on their hands going, well, I wonder if it'll redeem. I'll get around to that after the new year, after the holidays. Most of them are fairly well organized. I mean, it's a year redemption period. This is not like they have a 2-week window where they got to get something done. So even in relatively high volume, you can get this down to where it's kind of routinized and you have sort of a calendar year look at it where you can say, okay, in March I'm doing this, in May I'm doing this, and in September or in August or September, I'm doing this. You can kind of get it down.
Got it. So is it the collector's deed? You have to have it recorded. Does that get recorded by the county before they issue it back to you, or do they give you the deed and you have to go get it recorded yourself?
No, my experience is typically that the collector records it and just sends you a recorded copy.
Okay.
And
so you don't have
a lot of the counties that I practice in, the collector's office is in the same building as the recorder of deeds, so they usually do that.
Okay. I can't remember what state it was, but there was a state where they give you the deed, but it's your responsibility to go record it in that time period.
That would make some sense, because then they don't have to get involved in the middle of collecting the fee to have it recorded. But Missouri is just always, as far as I know, and maybe there's some counties that vary from that, and I'm just ignorant of that because I don't have any exposure to it. But it's my impression most of them, you pay the fee to the collector, and then they go get it recorded and then just send you a recorded copy.
Got it. Okay. So now you have this collector's deed. So let's talk about what that means. You have ownership of the property, but is that deed insurable? Do you have to do any other steps to get insurable title?
It is perhaps marketable, perhaps, but it is not insurable in Missouri.
Okay.
So that's really one of the main reasons I've gotten involved in this area of law, is because when, let's say I have a client that bids on 10 properties, 8 of them redeem. Well, with those 2 deeds that they get, then I'm taking each one of those through a quiet title action. And depending on the county, I usually do them on a flat fee if it's uncontested, and that's cradle to grave. That's filing, service, reducing it to judgment. I'll even do a little bit of negotiation here or there if it's somebody that, if it's not creating a major problem within that flat fee. And then it's also getting the judgment signed and then recording that judgment in county land records as well. So it includes all that. If it's recorded, or I'm sorry, if it's contested, then I'm typically converting or in addition to the flat fee, then charging hourly to defend or prosecute the case, as the case may be. So yeah, you're typically doing a judicial judicial confirmation of the non-judicial foreclosure process. And the Missouri statutes provide specifically for quiet title actions on collector's deeds, and they have some pertinent provisions as to how that works. And that's important because you want to plead some of those things as to what you get if you don't lose, or what you get if you do not prevail, or what you get if you do not prevail in certain ways. So if you fail a statutory requirement versus if you fail a constitutional due process requirement, and that matters as to what you end up with. So it's not insurable. You typically want to get a quiet title action done, and you want to try to get one done by somebody that has done these and knows what they're doing a little bit, because it's not a run-of-the-mill quiet title action. I really think there are some specific things that you want to plead to make sure that all your bases are covered and you've really protected the investment of the tax sale purchaser should the tax sale purchaser not prevail in the quiet title action, or at least even partially not prevail.
Got it. That's that quiet title process. How long does that typically take?
Depends on how many defendants you have, because the service of process is always something that can take a while if you have numerous defendants. I would say in a typical uncontested quiet title action it would take us maybe a week or 2 to get it filed, just depending on my schedule and when I can draft it. We're pretty good at this stuff now. We've got support staff. We've been doing it a while. So we can usually get it on file within a couple of weeks. From filing to judgment, you're talking at a minimum 90 days. It wouldn't be at all uncommon for it to be 120 or 150 days, something like that, to get it all done, even if it's uncontested. Now, if it's uncontested and you have one defendant that you got served right away, well, yeah, you could probably get to a judgment in 60 days, but I like to under promise and over deliver, as opposed to, the opposite of that. So,
3 to 6 months in general, unless it's I'll say nasty or a lot of people that you have to serve, and then it becomes a very long drawn
Yeah.
out.
So I had one case, for example, where there was it was formerly owned by an investment company that was allegedly running some kind of a Ponzi scheme. And so there was 38 judgments against this company, had nothing to do with this particular property, but they were all judgment creditors of this company. And so we had to name, so that takes a long time. That's a totally different ballgame. So that it just takes you a while to get everybody served and get everybody situated. And sometimes you get non-S returns and you have to do something else. Sometimes you have no idea where these people are and you have to publish notice. And in Missouri, it takes, especially depending on the county, it can take the court a while to approve publication notice. And once they approve it, it's 45 days from the first date of publication. So if you have to publish notice on a case, you're at a minimum 90 days for that case to get to a judgment, and probably a little bit longer. If it gets nasty and contested, well, it's a regular civil case. This isn't a court of, you don't file these in courts of limited jurisdiction, even though you're not really seeking specific damages from somebody that exceed the jurisdictional amount. It's still filed in regular civil, and so courts don't get in any real big hurry if it's contested. They want the case to play out and for people to have their opportunity to do discovery and have their day in court. There is also a portion of my paper that talks about jury versus non-jury trials, and of course, if you get set for a jury trial in part or all of the case, that can take even longer. If it's contested, you could be looking at a year or two to get to trial, and then you could be looking at another year for an appeal. So these can drag on for sure.
What any idea, rough percentage of how many are contested versus non-contested? Is it
probably about the same percentage that redeem versus non-redeem? I would say if I file 10 cases, I'm going to get one of them, maybe two of them that's contested.
Okay.
Some of them are not contested seriously, and that that's just kind of my own anecdote about it. It's somebody that sort of has an interest in the property or has a problem with something that you did, but they maybe don't really want the property back. They want to just kind of get it resolved somehow. And so it's sort of contested, but not really. And then some of them are like, this is our family home, we're staying and we're going to the mat on this thing. And those are the ones that can take a really long time. Sometimes if they're kind of contested, but not seriously, you can still negotiate it out and get it done within a few months.
Got it.
The ones that last a year or two or three are needles in haystacks. It doesn't happen it's not super common.
Got it. Now, is there one of the questions that I kind of missed, I guess, is part of the getting that the collector's deed. Liens, are there any liens that survive, I guess, or I'd say code violation fines, IRS liens? I'm assuming Missouri, like most states, where the mortgage is wiped out, but what about mechanics liens and so forth? Is there anything that survives?
There are, I think, 3 things that survive, and I usually plead this too, just to make it clear. Let's see if I can remember them off the top of my head. Easements of record, easements in use, and publicly recorded covenants that run with the land. So let's say you buy a tax sale property in a subdivision that says you can only paint your house brown, black, or white. You can't go in there and buy a tax sale property and paint your house pink. Those covenants that run with the land survive the tax sale specifically by statute. And then also, of course, easements. What's in an easement? Well, you might have an access easement to another parcel. Well, you don't get to tear up the road just because you bought a tax deed. The other thing that's on easements are cell phone towers, usually. So, consider that. The other things that survive would be interests that I need to word this carefully, because here comes the difference between statutory and constitutional due process compliance. let's say you sent them a notice that was compliant with the statute. You did a basic job getting your notice out. But for some reason, fact specific to that lien holder, you didn't do quite enough in the court's view to comply with notions of constitutional due process, meaning reasonable notice calculated under all the circumstances to achieve actual notice. Let's say you didn't quite do enough. Then the court can, in its judgment, state that your collector's deed is not invalid in and of itself. It's valid, but it's taken subject to that lien holder's interest. So that's why it's important whether or not you failed to comply with the statute versus whether you failed to comply with constitutional due process. So if you fail to comply strictly with the statute, the court is most likely going to say your collector's deed is invalid and they can redeem from you. It's not a redemption, but that's just a shortcut way of explaining it. So if you fail constitutional due process analysis, then it might be taken subject to that interest. Basically, all other interests, mechanics liens, IRS liens, mortgages, you could throw out a few more, but basically all those other kinds of unrecorded interests, all those types of things are all extinguished by the tax sale foreclosure process in Missouri, because basically the state is selling its lien on the property and the state's lien is first and primary to everything else. So you're basically buying into the top spot.
Got it. Interesting. Okay, so it's a cleaner from a lien perspective, that collector's deed, than in many states, because usually there's a few that survive code violations. I think IRS is one that survives in a lot of states.
Yeah, I'm glad you said that. The fourth one, there is a fourth thing that survives by statute, which is subsequently due taxes. You don't. Okay. It's explicit in the statutes that future taxes are not ever extinguished, or liens that came into existence subsequent to the sale for which you bought the tax sale certificate, those are not wiped out either. So if for some reason you procured a collector's deed, and I think this was more relevant before some of the amendments to the statute, but if somehow you procured a collector's deed without paying subsequently due taxes, the lien for those taxes would continue. You never get out of paying future taxes from the point at which you paid the taxes.
That'd be a good trick if that actually happened.
If it were,
yeah. Happening anywhere. So all right. So as far as timeline goes, if you do everything right, you can have a collector's deed within a year. And you mentioned it was marketable. So is it accurate to say you could sell that collector's deed, but the only way you could sell it is on a quick claim deed basis at that point?
Yeah, I probably wouldn't want to put in any warranties of title, and I think a buyer would be foolish to accept a general or special warranty deed on it. I think a quick claim deed would probably be all that you could do. But also what some investors do, especially if the property is vacant or abandoned, then they begin acting like an owner. For example, they become responsible for code compliance. So like weeds and trash and that sort of thing, they become responsible for that upon the recording of the collector's deed. If it's abandoned, they might fix it up at that point and be relatively secure in their investment in doing so. They might rent it out. But if they're going to refinance it or sell it, then they probably are going to need the collector's deed recorded in conjunction with a recorded copy of a quiet title judgment to do any of that stuff with it.
Got it. Okay. And then
if it's not vacant, if it is occupied, you're not going to be able to get anybody out without some sort of a lawsuit for ejectment. And so if I typically include account for ejectment in my quiet title actions, just because a lot of times we're not really sure if there's anybody living there. And even if we thought there was nobody living there at the time we sent notices, for example, we don't know if anybody's squatting or whatever. So a lot of times we'll do account and ejectment also. That has some other legal implications as far as jury trials and whether or not you've opened the door to a jury trial. But typically we want to if we get quiet title, we want it to say that it's for possession also, in case we need to get a writ and get the sheriff out there to put somebody out.
Got it. Okay. And then usually another 3 to 6 months after that first year for the quiet title until you have, insurable or marketable title at that point. What, I guess really kind of the last question I have for you, Scott, is we've covered a lot, and there's certainly I guess I have 2 questions. There's certainly a lot of places where attorneys could and should be involved, but in general, where do investors typically involve attorneys? Is it at that March notification, or is it at that start of the quiet title? Is there a norm?
Yeah, it depends on the sophistication and comfort level of the investor. The more new you are to it, or the less confident you are about it, the more your attorney should be involved. And it doesn't have to really get all that expensive. I mean, if it doesn't take me much time at all, a lot of times, I don't even bill for it. If it's going to take me more than 5 or 10 minutes, then yeah, I'm typically billing for it. Most of the time, the attorney would definitely be involved in the quiet title part of it, the judicial confirmation of the non-judicial foreclosure process. But attorneys could be involved from the very beginning, as far as so a lot of investors will do some diligence before the sale, because they kind of want to have at least some idea of what they're buying, and maybe there's certain types of things that they want to avoid. An attorney could help you through that. You can go get, an ownership and encumbrance certificate from a title company for not too much money, and figure out, hey, am I stepping into a hornet's nest here, or is this something with one owner that, somebody that died and didn't, give the property to anybody? It's vacant and abandoned, that sort of thing. So an attorney could help you on that. Attorney could also help you with auction strategies and help you understand how that day of is going to go. Mm-hmm. Attorney could definitely help you order title search reports. They probably know, as I do, they know the title companies that are good, that will give you these reports timely and for a reasonable cost. And then attorneys can definitely help you send notices, evaluate who gets it, who's entitled to a notice legally, where to send a notice, what to do if those notices come back. And especially if that attorney has knowledge of the particular collector involved. There's certain collectors I know that our applications for deed are probably going to sail through without much question. And then there's other collectors I know that are going to kind of look at it pretty closely. Mm-hmm. And so they can help you kind of prepare for that. They can also, help you with having an open dialogue with that collector to work on getting the collector's deed issued, because they have some discretion and a statutory grant of discretion now. So it's kind of they're the gatekeeper, and so you gotta work through that process. And then after you get a deed, of course, they can help you transfer the property. They can help you refinance it. They can help you get through a quiet title action. And I've helped clients get through closings with certain indemnifications due to things that have happened with the deed. I have helped clients collateralize their investment portfolio, all kinds of things. So it just depends on what it really depends on what volume the collector the investor is doing business in, and where and how much and kind of what they need. But one thing I left out of that whole thing is registering for the sale. Especially if you're an out-of-state entity, there are a lot of reasons why you don't want to be an out-of-state entity investing in tax sales in Missouri. And so I can help them. I have helped clients get registered in Missouri so that they can be a domestic bidder as opposed to a foreign bidder. Yeah, and
I kind of made a note to come back to that, because that was I don't know if it's a myth, but it's certainly an answer that I get from institutional folks in general of, hey, are you active in Missouri? And typically the answer is no. We're not. We don't have anybody that's a resident of Missouri. You've got to be a resident of Missouri, and so we're just not active there. Now it sounds like that's maybe a myth. So can you help me understand how if you are from out of state. If you're not a Missouri resident, how can you participate?
With good reason, it's a myth. It's because the language of the statutes are basically internally inconsistent. And so it's an unanswered question, and nobody wants to be the wrong answer to that question. And so there are a couple simple things that you can do. Number one, you need to work with a collector. Number two, so that they understand who you are and what you're doing. Yes, you need a resident of Missouri in some counties. Frankly, I serve in that role, so you just have to have some resident. But here's the other thing really that you do, especially if you're an institutional type of investor. You form a Missouri corporation or LLC, and then you bid as a domestic bidder with a domestic registered agent. What those statutes basically are getting at is they want disputes about the sale or the property to be handled in Missouri courts. And by registering in Missouri and having a registered agent and having a resident bidder, basically, you avail yourself of the jurisdiction, and that gives you, that gives them the reassurance that any dispute about what happens would be resolved in a Missouri court. There's some language in the statutes about how you go about doing that, but there's also this kind of outlier phrase in the statute that says, no bid shall be received by a foreign entity. And so Louis Brandeis once said, I can't tell you how not to fall off a cliff if you insist on walking on the edge, but I can tell you how to stay away from the edge of that cliff. And that's true here. I can't tell you whether or not as a foreign bidder you would get an invalid collector's deed, or it could be invalidated later by a particular lien holder or a homeowner. But what I can do is help you stay away from that cliff so that you don't run into that issue.
Got it. So you can. So that's another part where you as an attorney can help. Is you can act as that agent or local resident in registering for auctions.
Yeah.
Got it. Okay, great. Well, I'm glad you remembered, because that is probably the biggest subject that's talked about from at least when I talk to investors that aren't already active in Missouri, because they come across that. Because usually the first thing you do is, as a sophisticated investor, is you go read the statutes yourself, right? Read statutes, and that is something that is glaring, like you said. It says you have to be a resident, and most folks would be like, okay, well, I'm not a Missouri resident. That eliminates Missouri for me, but that's not the case.
Yeah, I don't think that's necessarily the case. Yeah.
So my last question is: there's obviously a lot of things that need to be done on a very specific timeline. Done in the right way. Sent to the right person. So there's a lot of potential pitfalls, to fall into if you don't do things the right way. What in your mind is the biggest pitfall, or maybe two biggest pitfalls that you see that investors should avoid?
Not knowing enough about the property before they invest in it, because I see at times after the investor gets involved in a property, they, for whatever reason, don't want it anymore and write it off, so not understanding what's involved in it in the first place. Mm-hmm. And then the second one, I would say, is probably just in that it's kind of 1A and 1B, the language of the notice, and then the follow-up efforts to give notice. For example, all these things all the notices are going to be reviewed by a judge sitting in Missouri. Mm-hmm. And as an out-of-state investor, you may not know certain things about Missouri. For example, like Missouri's public access to court records on CaseNet. Anybody in Missouri knows you can search for somebody's name on there and try to find them and find addresses. And I've had cases where that search has not been done. A more recent address was not uncovered there, although it could easily and basically for free could have been discovered. And that was enough for a judge to say, yeah, I don't think there was compliance with due process here, and enough to award it back. So And then one of the other pitfalls, and getting the right language in your notice, and then appropriately and timely following up to make sure that any follow-up diligence that needs to be done is done. And then maybe just as an overall investment strategy, not being ready for most things to redeem. And getting, especially like smaller type investors, mom and pops, family money, that kind of thing, being really specifically interested in one parcel. And let's say it's like some really nice house, or it's lakefront, or it's whatever. Well, I mean, don't go get carried away because that chicken hasn't hatched yet, that kind of thing.
Got it. So don't bet the farm on a single parcel. Definitely do your due diligence, which is recommended across the board, and make sure your notifications are correct. Would be the top three. Excellent. Well, I mean, I certainly immensely appreciate your time today, Scott. I learned a lot. I think anybody that has even loose interest in Missouri will have much more interest knowing that they don't have to be a Missouri resident. The process is a good one, and it's got a reasonable timeline. And I think people will definitely be very interested in seeing how Missouri tax sales work in more detail. So thank you again for joining us. I appreciate your time, and I'll look forward to seeing you at the next NTLA. If they, it sounds like they might have one in the spring. They canceled fall, but we'll maybe see you in the spring.
Yeah, I need to get out there to one of those.
Yeah. Well, we'll see you in the spring.
All right. Thanks, Brian. It's been a pleasure.